Thank you for inviting me to testify today. My testimony is divided into two parts. First, I'm going to summarize the major enforcement actions that have been brought by my office and other State Attorneys General against lenders and other participants involved in the collapse of the mortgage market. And second, I will identify some of the key impediments to effective enforcement of consumer protection laws at the State level. Because State Attorneys General are on the front line of consumer fraud, we hear about problems as they're happening. And let's debunk the myth that the predatory practices in the mortgage lending industry just started a year or two ago. In fact, we have been pursuing predatory mortgage lending practices for over 10 years. In that time, State Attorneys General have often targeted very large mortgage lenders for investigation, because our aim is to bring cases that will have an impact on the lending practices of the industry as a whole. In 1998, Illinois, Massachusetts, and Minnesota brought civil consumer fraud suits against First Alliance Mortgage Company, a California-based lender. FAMCO's business and lending practices will unfortunately sound very familiar to you. FAMCO sold high-cost home loans to subprime and prime borrowers. Most of its loans were refis, with borrowers typically placed into a 228 ARM, one of the same products that is causing so much trouble in the current market. Another foreshadowing of today's crisis, FAMCO bundled and sold its loans on Wall Street to Lehman Brothers. As a result of being sold unnecessarily high-cost home loans, FAMCO borrowers paid the price in the form of higher monthly payments and lost equity. In a settlement of the lawsuit in 2002, the states recovered well in excess of $50 million in restitution for consumers' losses, and FAMCO was ultimately forced out of business and into bankruptcy. In the years since FAMCO, the states have brought a succession of enforcement actions against some of the biggest names in mortgage lending. These actions include a multi-state investigation of the subprime mortgage giant Household Financial, which culminated in a $484 million settlement in 2002. Following the household settlement, the states launched a probe of AmeriQuest, the largest subprime lender in the nation at the time. The AmeriQuest investigation was resolved in 2006 when the lender entered into a $325 million settlement agreement with the states. All of these enforcement actions targeted the kinds of fraudulent, unfair, and deceptive practices that eventually led to the collapse of the mortgage market. By the fall of 2007, as the subprime mortgage market was starting to crumble, my office opened an investigation into the lending practices of Countrywide Home Loans. At the time, Countrywide was the largest prime and subprime mortgage lender in the nation. My investigation, which was conducted in conjunction with the California Attorney General's office, revealed that Countrywide had engaged in a wide range of deceptive lending and marketing practices in relentless pursuit of greater market share and profits. As a result of our investigation, I filed a lawsuit against Countrywide in June of last year, and in October, I and several other State Attorneys General announced a settlement with Countrywide's new owner, Bank of America. That settlement established a mandatory loan modification program that covers approximately 400,000 borrowers nationwide. The program is estimated to provide $8.7 billion worth of loan modifications to borrowers and give them a fighting chance to stay in their homes. A mandatory loan modification program, which requires the lender to review its most toxic products and modify its loans, is at the heart of the Countrywide settlement. In my view, saving homes and stabilizing communities must be the primary goal of any enforcement action against predatory mortgage lenders. Unlike previous settlements with major lenders, the Countrywide agreement could not prohibit the company from engaging in deceptive lending practices in the future. This is because once we subpoenaed Countrywide, the company moved all its lending business to its federally chartered subsidiary, which State Attorneys General are arguably prevented from investigating due to OCC regulations. In other words, the lenders, supported by the OCC, argue that the states are preempted. We devote a tremendous amount of resources to investigating and prosecuting the many other state licensed participants involved in the mortgage meltdown, including brokers, title companies, and appraisers. Congressman Waters, to address your concern about mortgage rescue fraud, I want you to know that the State of Illinois has brought 22 lawsuits against mortgage rescue fraud companies, and we have outlawed upfront fees being paid for these services. Our prosecutions of these wrongdoers are both civil and criminal and remain a vital part of our enforcement efforts. While the states have been aggressively pursuing enforcement actions against major lenders and other industry participants for years, our efforts have been impeded by a number of obstacles. State enforcement actions have been hamstrung by the dual forces of preemption of State authority and lack of oversight on the Federal level. In the run-up to the crisis, many federally chartered lenders were engaging in the same predatory practices as State-licensed lenders. The States, however, could not pursue these Federal lenders, even though we would have liked to. When a report showed that several lenders in the Chicago area had possibly violated fair lending laws, I could send subpoenas only to the State-licensed lenders implicated in the study. 2 of those State lenders have since moved to Federal charters to avoid our investigation. Preemption is a clear impediment to our investigations of fair lending and consumer protection violations by Federal banks. To give you an appreciation of the preemption battle, there is currently a case before the United States Supreme Court where a coalition of national banks is challenging the authority of State Attorneys General to investigate violations of State fair lending laws. And we all know the reason that national banks have fought so hard to block States from enforcing State laws against them. Over the years, efforts to preempt State consumer protection powers have left a large gap in regulatory authority. So far, the Federal agencies have been unwilling to fill this gap, and the national banks are counting on their regulators to remain similarly resistant in the future. As home loans grew increasingly complex and risky, Federal regulators could have and should have taken steps to ensure that lenders evaluated borrowers' ability to repay their mortgage loans. Unfortunately, Federal regulators chose not to exercise their authority to enact uniform market-wide underwriting standards until the mortgage market showed the first signs of the meltdown. By then, it was too little and too late. To conclude, I would say the best thing you could do is prevent further preemption. Give us the authority that we need to go after Federal chartered banks as well. Thank you for this opportunity to testify, and I would be happy to answer any questions you may have.